Welcome back, everyone, to another episode of the Canadian Immigration Podcast. My name is Mark Holthe, and I'm here with my co-host, Alicia Backman-Beharry. How are you, Alicia?
I'm doing well, Mark, and I wanted to do a podcast on spousal and dependent children open work permits because this is one of the kind of few rays of light that people still have when they're looking at, do you actually have an open work permit option? And I think sometimes we forget about it. It's one of those things that has been in existence for a couple of years, but maybe people didn't really pay much attention to it. And knock on wood, it hasn't been revoked yet.
Yeah, it's been around for a while. And if we look back over here, Alicia, at the public policy here, this was originally announced back in February of 2023, and we'll talk about this a little bit more. But as you think about all of these programs, the only policies we've seen right now are ones that are being shut down or canceled or closed just with the government's tremendous effort to reduce the number of temporary residents in Canada. And I was just reading this morning the submission put forward by CELA to the government just on the more cavalier they are process they're using to refuse temporary resident applications without really any meaningful adjudication of these. And we're happy to see that these work permits and if there are refusals, they are now including to some extent the GCMS notes, but they really contain no substantive information, which says that they're not really entertaining or examining the evidence and giving any form of an individualized assessment based on the individual's actual background. So, yes, applying especially outside of Canada, although we are starting to see a little things happen, a little more strict interpretation from within Canada as well. But this policy, like you've indicated, is somewhat of a ray of light. And so, why don't we just dive in? Because there is a little bit of confusion about it. But the first thing I want to talk about, Alicia, is who can apply. Now, those of you who are listening, you can easily go to our website, Holthe Immigration Law. It's at holthelaw.com, and go to our blog section. And on September 11th, just a week ago, Alicia released an awesome blog post that covers a lot of the content we're going to be talking about today. But let's start off right from the beginning. So who can apply, Alicia?
Mhm. Mhm. So it's important to keep in mind that we're not talking about work permit holders and spouses of temporary foreign students. We're not talking about PGWP holders. We are only talking about people who have filed a spousal sponsorship application for permanent residency. That's it. And there are, of course, two different categories of spousal sponsorship. And sometimes people don't realize this. I get a lot of questions about this. So I wanted to start off with, okay, what is the difference between a spouse or common law partner class? And what is the difference between a family class under Division 1 of the Immigration and Refugee Regulations? So this is really important because we have what's commonly known as a inside Canada spousal sponsorship, and that's the SCLP. And then we have the family class application, which was historically known as the outside Canada sponsorship class. Now, the reason that it makes a difference is because under the family class application, people actually have a right of appeal to the Immigration Appeal Division. So, family class, right of appeal. Right now, processing times, right? If we look at the processing times for a family class application as of last week, they were 13 months. If we look at the processing time for a spouse or common law partner inside Canada class, it's like 36 months. So a huge difference in processing time. And then the other fantastic thing about the family class application is that you theoretically can leave and enter and exit Canada. So the problem with a spouse or common law partner in Canada class is that if you file from inside Canada and you leave Canada, there is a possible, and they changed it. So the processing time has actually gone up since last Thursday.
Wow.
So now it's 15 months. Yeah.
It's not surprising, Alicia. It's not. We're just those of you who are watching the video of our podcast. I'm just showing right now as of September the 2nd. Um, it said it was last updated September the 2nd, but I don't know if I buy that because I looked at it and it was 13 last week. But anyways, it
hmm
says now 15 months processing for an outside Canada. And
Hmm.
but understand these are global averages, so it is
Yeah.
possible some regions we could see things move forward a little bit quicker. But yes,
Hmm.
this is constantly changing.
Hmm. So still though, you can and maybe look up the outside Canada, or sorry, inside Canada processing times for SCLCP
Yeah.
and see if those have bumped up as well, because it's
Yeah,
interesting
I
to
just pulled
see.
that up. It's sitting at 23 months. It's actually come down.
Yeah. So here
Isn't
we
that
go.
weird? So guys, this was like we were over. Were we ever at 30? We were. We're over 30, like
Mhm.
32, I think. And then now it's
It was
10 months. It's
36.
dropped 36, like
Yeah.
3 years. Like it's just I don't know. I'm trying to trust this, Alicia, but even this September the 2nd, we're recording today, September the 17th, and I'm positive that this was. I looked last year. Sorry, last week, just last
Yeah.
week, and
Yeah.
we were over 30. So
Yeah.
you take this with a grain of salt and you try to plan accordingly, but the gap between the two is starting to narrow. Interesting.
Yeah. Yeah. So we'll see about the processing times. For the last while, it has been basically double for the inside Canada. And people say, well, why is that? Well, because the rationale from IRCC is spouses are together. They're reunited, they're in Canada, they're hanging out, they're doing whatever they need to do until they hopefully get their PR. So that's the justification for it. The interesting thing is that historically, if you filed a family class application, you were not eligible for an open work permit, period. End of story.
Yeah.
So the other interesting wrinkle is that, and this is what people often do not realize, you can file a family class application if you are physically present in Canada, if you have status. And so technically you're under the family class category, but there's nothing in the definition that requires you to be physically outside of Canada. So you could theoretically, if you had a valid visitor visa or your ETA or visa exempt, you could be inside Canada and you might file. And where you make that determination is when you check off your document checklist when you're filing that document. So keep in mind when we're looking at this public policy, the important change has been that as of February 9th, 2023, this was when Minister Fraser was still here, he said, you know what, we are going to allow open work permits for family class applicants if they meet a number of requirements. And this is going to apply for spouses who are sponsored, and it's also going to apply for their dependent children who are part of that sponsorship who are accompanying family members. So that's a really important shift because it actually gives a lifeline to people who are in Canada who actually decided to file under the family class so that they can preserve their appeal rights, they can get hopefully faster processing times, and they can leave and exit and re-enter Canada if they need to, because the risk under a spouse or common law partner class is if you leave, you might lose your application. And so if you file under the family class, you have a little bit more, uh, you can hedge your bets a bit more.
Gotcha. And realistically, Alicia, when you look at this, um, on the surface, it sounds, hey, great, you can include dependents. But remember, how often do you have a married couple or a common law couple that are, a Canadian sponsoring their spouse or a permanent resident sponsoring their foreign spouse who has a child that they themselves is between, the age of 18 to, 21 or I don't know if there's an age that's below that. It's just adult 18 to 21, I think is the range, right? Once you hit 22, you're no longer a dependent. I think is that
Right.
the same definition?
There's no restriction. Like if you have a 17-year-old and you wanted to get a work permit for them and they were eligible to work in the province and you're meeting the minimum age requirements under employment standards, you could apply for a work permit for that person.
Okay.
But you're right, they have to be the dependent child who is an accompanying family member under that spousal sponsorship.
Yeah.
The other thing that we'll go through the IRCC interpretation as well, but it's buried. It's not in the IRCC interpretation. It's actually only in the temporary public policy. There's a maximum duration on that. And so when you are making the request, you can't ask for more than 2 years. If you ask for more than two
Mhm.
years, you're going to fall outside of the temporary public policy. So pro tip, make sure that you don't ask for more than 2 years. So that's where it is. It's right in that temporary public policy. And it says that when you are asking for a maximum of 2 years, it's sub II. Mhm. So the next thing is, all right, who's going to be eligible? Let's kind of dig down into the details of this public policy and how IRCC is interpreting it. So the foreign national has to be the principal applicant. So, and they have to be under either a spouse or common law partner sponsorship or under a family class sponsorship. And IRCC has had to actually accept that sponsorship for meeting completeness under Regulation 10 and under the ministerial instructions that say that it requires a complete package according to the website. All the checklists, requirements are there as well. And so
So, Alicia, how do
basically,
you know that? So, how does
mhm,
someone know that
yeah,
they've reached this stage?
yeah. And so historically, IRCC has said, well, that means there's a genuine relationship and the sponsor has received an acknowledgement of receipt or approval in principle. And we'll get into when you need an approval in principle versus when you need an AOR, because those are very different things. So this is how they tell you that you have passed kind of this first completeness check acknowledgement of receipt, or in some cases, you got to go further down the road for approval in principle. And we'll get into that in a second. But the next thing is if you filed that spousal and you have that AOR, most of the time it's just the AOR, then you also have to submit a separate work permit application. And Mark, you and I remember way back in the good old days
The good old
that
days. Yes, indeed.
the good old days when you could file a spousal and you could file an open spousal work permit all in the same package, off it goes, and you're good. No longer, right? So they
No.
changed that.
And that was
And
so
you,
good, Alicia. Like when I
yeah.
think about in in those days, it was often a situation where people would be running out of time on their work permits, right? And then
Mhm.
we would, they'd be eligible to file a spousal sponsorship. So we would file that and we would include an open work permit at the same time, which would then allow them to benefit from maintained status and not be in a situation where they, are going to fall out of status. But now it becomes really precarious because
Yeah.
individuals are having to wait this extra time. And there was a period of time where it was 3 or 4 months before you got it back. And people were falling out of status. And so it creates another level of complexity that I know from an operational standpoint, IRCC just wanted to separate them out so that they could have them processed through different units and not have to manually separate them themselves when they receive spousal sponsorship. It's all about efficiency. But my goodness, Alicia, when they had those discussions, processing times were like 12 months, and that was across the board. And now,
Mhm.
well, as we talked about it, they're climbing and jumping up and dropping down.
Yeah. And that's exactly why I wanted to write this article and have this podcast, Mark, because I think it's really important for couples to realize if you are in Canada, you're falling out of status soon, you really, really have to think ahead. File that spousal sponsorship, wait for the AOR, then you have to do a separate work permit application. So that's kind of procedurally what has to happen. And there's time. You got to build in time for all of that. So the next part of eligibility criteria is that you actually have filed a separate work permit application. And there's a particular way you have to file it, which is what this article that I'm writing is all about. Not only that, the spousal sponsorship has to have been submitted by a Canadian citizen or a Canadian permanent resident if you're looking at a situation where they are residing in Canada, a common law or a conjugal partner. And keep in mind, you can't do a conjugal partner sponsorship if it's an in Canada application. It has to be a family class application for conjugal. So the next eligibility criteria is that they have to live at the same address. So you can't make use of this temporary public policy if you happen to be living at different addresses. So important to remember. And then the other thing is that, and this is where it gets tricky, the foreign national spouse must have a valid temporary resident status in Canada or be eligible for and have applied for restoration of status.
So in practice, this restoration period allows for a small grace period. So if someone's work permit once again is expiring and you file this spousal sponsorship as quick as you can, and then you're waiting and it expires, then the question becomes, should I have submitted a temporary resident visa application and then a work permit, which is probably what we recommend because we don't want people to fall out of status. But does this policy allow you, Alicia, if you have filed a temporary resident visa application, well, I should say a visitor record application, does that mess things up if you then want to apply through this policy? So,
Yeah.
because it says valid temporary resident status, it doesn't say valid
Mhm.
work permit. And
Right.
so, we typically don't counsel people to fall out of status, but if for whatever reason it did, then what this is saying is you have up to 90 days for that restoration period
Mhm.
to submit this.
Yeah, and then we'll also get into another wrinkle below if you don't have AOR, right? And then we'll also get into another wrinkle of there's another temporary public policy that's been in effect
Yeah.
for a number of years about if you're doing a spousal and you've already fallen out of status. But in that case, if you've already fallen out of status, you're outside of your restoration period of 90 days. Then you have to do a paper application and then you have to wait for approval in principle. So we'll go through that. Keep in mind, just like we said, it also applies for dependent children who are included as accompanying family members, but it doesn't as often occur just because of the practicalities of it. Um, I want to make sure that people understand there are certain circumstances where you cannot apply for this temporary public policy open work permit. So if you had your spousal sponsorship refused, like it didn't pass the completeness check, or it was withdrawn, or it was returned. I have had a number of consults where people said, oh my goodness, my spousal sponsorship was returned to me, literally, Mark, because there was one checkbox on their document checklist that wasn't checked.
A checkbox on the document checklist. So,
Mhm.
what if the checkbox on their document checklist was something that didn't apply to them? There isn't a way to
Um,
write NA on these secure PDF form. So, what do you do,
yeah.
Alicia, in that
I,
situation?
I normally go in with a PDF writer and put NA next to them.
Mhm.
Yeah, or
And
have
that's a
somebody
pro
do it by
tip.
hand.
That's a pro tip, you guys. So ultimately,
Yeah.
with a document checklist, you can technically print them and write
Mhm.
handwrite in not applicable on the sections that don't apply to you, because there's a
Yeah.
lot that may not. But you definitely don't want to leave any spaces blank. And
Yeah.
that's absurd, Alicia. They returned the whole spousal sponsorship, or was it a different application? It
It
was
was a
a
spousal.
spousal
Yeah.
because
Yeah.
they didn't check off like civil status documents or something on the document checklist. Even though they provided them, they just didn't check the box.
It well, it was a use of rep situation where IRCC said a use of
Oh,
rep had to be included, and they were like, no, a use of rep doesn't have to be included. So, anyways,
oh,
yeah,
yuck. Well, it's messy
yeah,
regardless.
yeah. So the other thing, you cannot apply at the port of entry. Do not go down in flagpole and ever try to use this public policy. It does not apply. You will not be accepted. You will get all sorts of grief at the border. Don't do it.
Yeah.
So important to remember.
Also, and that's also another recent change because it wasn't like this before either. You could go down, and when individuals were trying to get a work permit sooner, that's what they would do, and that's a good point. So if we go here and just look, because this is another factor people have to take into consideration, the processing times for work permits right now from within Canada are 100. Oh my goodness, they're back up again.
Yeah,
191 days. So
yeah,
just 6.5 months.
yeah,
So
yeah,
even with this policy, yeah, it's really, really painful. Um,
yeah,
really painful because not many people think that far in advance with their status, especially if they came as visitors here, right?
yeah.
So you're still waiting over 6 months to process in most cases.
Yeah, and that's important, Mark, because there might be circumstances where you are a spouse in Canada with a valid work permit and you're just doing a change of conditions to a new spousal open work permit. In which case, if you file it before your initial work permit expires and everything else applies, you would have implied or maintained status to continue to work. But you're absolutely right, Mark. If you're just here as a visitor and you've never had a work permit and you just file the spousal sponsorship and then you apply for the work permit, you cannot start working yet. You have to wait until you actually get that work permit sent to you and you have it in hand before you can actually start working.
Yeah.
Mhm. All
All
right.
right. So what if you don't have an AOR, Alicia?
And so this is interesting. This is not in the temporary public policy itself. It is in the interpretation from IRCC. And so the nice thing, like this is a little, I don't know, olive branch that IRCC is reaching out to people who are right about to expire. And so it's pretty interesting, but they allow an exception to the rule that you normally need an AOR. And so if you are applying for an open work permit and the foreign national spouse currently has a work permit, a study permit, or visitor status that is about to expire in 2 weeks or less, and the spouse or common law partner category class or family class application has been submitted, and the person still has status, then you can do this kind of little Hail Mary pass where you say, please accept my application for the open spousal work permit under this temporary public policy, even though I don't have AOR because my current document's about to expire in 2 weeks.
Yeah. And here's the question here. So, for the main steps to apply, this is the actual government website. So those who are listening, you can kind of, I'll try to walk you through it. It says how to apply. Do you have a valid temporary resident status? If we say yes, then it says, okay, you can apply for an open work permit. Once you get your AOR, you can apply for open work permit. You must apply online through the secure account. And then it talks about this policy Alicia is addressing. Who's eligible to apply for a work permit without an AOR? So if your work permit will expire in less than 2 weeks and you've applied through one of the programs. So this is kind of the olive branch, like Alicia said, that does technically allow us to some extent to make this request sooner. So,
Yeah,
but you
but you have to know it
still
exists.
have to have applied. Yeah.
Yeah. Yeah, the spousal sponsorship has to have been filed, and you have to know this wrinkle exists in order to make use of it because you only have a 2-week window. So this is why I wanted to bring some more attention to this category. And then the next thing is that just like you said, Mark, it has to be through the secure account. You cannot go down to the border. It has to be an online application. They give you specific program guidance about what you have to put when you are actually filling out that 5710 or the application to change conditions. What has to be written in each of those job title boxes. Make sure that you're properly putting that in there. Otherwise, they're not going to flag it under the temporary public policy. And you have to upload all those supporting documents. It's not going to cue you to do this. You have to know that you have to either provide the AOR and your current valid permit, and proof you submitted the spousal, the marriage certificate, stat dec if it's common law union. If you've got kids, you've got to do the birth certificate, all forms showing dual intent, all documents showing dual intent. And if you are trying to make use of that 2-week rule, then you have to show you filed the spousal. You have to get screenshots and fee payment receipts because you won't have the AOR, right? So you've got to have a stronger documentary know-how to make sure you put everything in there properly.
Yeah. And the hard part, Alicia, is that for people who are just applying on their own, you have to really dig to find this information. Like lots of times people just zip through this stuff and they don't even pay attention. They just jump through it and then they get down to the bottom and they advance to the next screen and they don't really carefully review these detailed things, especially how to fill out the application forms. And so, like Alicia pointed out, if you're not answering the proper thing in the proper box, remember it's electronically, like whatever version of AI is scrubbing it, looking for those specific codes that they have here. And if you don't put it, I wonder if you put it in lowercase, if it's even case sensitive. Ultimately, if it says write SCLPC FCOWP in the job title box, then I'm going to put it exactly as it is asking here, all caps. So these little nuances can literally make the difference between acceptance and rejection, because if you don't do this, they're not going to know for sure what type of open work permit you're applying for. And, obviously you want to provide your proof that your application has been submitted. So there's so many areas where this can drop off. So many areas where you can make mistakes that cause your application to be rejected. And the moment it's rejected, Alicia, you're outside of the maintained world. You're back into this crazy situation where, you might be able to restore your status, but you're waiting over 6 months for it to be processed. Who can just sit around and not work for 6 months? I know
Yeah.
I can't.
And that's why hopefully you filed under the family class. And if you had status, then you can go and you can come back and work outside Canada and then come back, hopefully. So, but all these things matter. All these details matter, which is why I'm going through them, why we're talking about them today and trying to highlight them, because it makes a huge difference in people's lives.
You bet. Okay, so the second and I guess the final little piece is when you don't have status, then how does this play out for you? You kind of hinted at it, but it's important to know for people who, whatever decision, they got some advice. Just stay. I'm not going home. I've got nothing to lose. I'm choosing to stay here without authorization. And then they find their true love. And then they decide to file a spousal sponsorship. And this is
Yeah.
where the policy kicks in. And you guys can go back through our YouTube channel. You can look back to past blog posts, like we've talked about the public policy for spouses. And essentially what it does is it defers removal of someone from immigration if they have an in Canada spousal sponsorship application filed. And it
Yeah.
also has the ability to kind of save someone who's been out of status in Canada. But everything has to line up, and more so than ever before, IRCC is adjudicating these things just with a strict interpretation. They're not giving people benefit of the doubt. So, yeah.
Yeah, and the where you can find this, if you actually want to take a look at what that other public policy is if you flip back, Mark, to the IRCC guidance, and you actually take a look way down at the bottom of the page, and just like you said, it's buried, so it's hard to see. So if you go down to the bottom of this page, and it says, how do you apply? And it says, if you don't have status. So if you click scroll up a little bit to whether you do or do not have status, keep going up, keep going up. And you're going to have to say, instead of I have status, you say, no, I don't have status. A little
Oh,
bit higher
sorry.
on the page.
Right here,
Yeah,
right there.
right there. So if you don't have temporary valid status, you look here, and this is going to link you to the other spousal public policy. And this is under section 825, so the H and C sections of IRPA, that talks about, just like you said, in some circumstances, they will save the ability for married or common law partners to advance a spousal sponsorship, even if the foreign national spouse does not have status, has fallen out of status. So this is an old public policy.
Yeah, it
Um,
is. I
yeah,
remember, Alicia, I guess it's kind of fun to add some interesting anecdotes, but I remember when this policy was created. And so basically, it stems from, it's always political. And I remember Minister Scrow, Judy Scrow was the minister, our liberal immigration minister. And at the time, there was no policy that prevented CBSA from removing individuals from Canada, even if they were the subject of an in Canada spouse common law partner application. They said, well, it's not a hardship. Just we're not going to approve your visitor extension, and so you have to go home. And so there was a Romanian lady who was a exotic dancer, and they called it Strippergate. But anyway, she was an exotic dancer who married a Canadian, and she didn't want to live that lifestyle anymore, I guess, and so she wasn't working, so she couldn't maintain her work permit, and so they transitioned to her visitor status. And they tried to apply to extend it, and it wasn't approved. And so the recourse back then was a temporary resident permit. And the minister has the authority to issue those. They used to be called minister's permits, but the temporary resident permit, they have the authority to issue it. And so they applied for one, and it was approved. And I think that was the right decision to make. But the problem was she was volunteering a little bit on the campaign of Minister Scrow. Mr. Scrow probably didn't even know her hardly, right? And but at the same time, the media gets a hold of it, the opposition party gets a hold of it, then it became this big thing, like favoritism for people who are, working on your campaign. And so at the end of the day, sometimes good things come from tough situations. And so in this case, the public said, yeah, like there should be like we shouldn't be removing these people who are in genuine relationships with their Canadian spouse. If one of the pillars of the Immigration and Refugee Protection Act is the reunification of families, well, why would we be sending them home? And so this policy was created, and I think it's a good policy, and it allows individuals who, even those that have fallen out of status to be able to stay and until a decision is made on their applications. And yeah, I think it's a good policy.
Yeah. And it prevents people from, just like you said, Mark, having to file a TRP. And the IRCC does not want to be inundated with TRP applications. So when they're looking at genuine spousals, so it has passed kind of that completeness check and there's nothing saying that it's a marriage of convenience, when you're at that stage, well, then let's use the public policy. Let's keep people in status. Let's allow them to apply for a work permit. So that's the rationale. And so if we circle back to the second scenario, where most of the time it's going to be where the foreign national spouse has valid temporary status, and keep in mind that could be a work permit, it could be a study permit, or it could be visitor status. If you don't have valid status and you're outside of those 90-day restoration periods, then you can still apply if you did file your spouse or common law partner or FC1 application under that old temporary public policy, but you cannot apply online. You have to apply on paper. And the difficulty with this is you cannot just have AOR. You actually have to have your approval in principle. And
Yeah.
I will reiterate this. Approval in principle is not the same as your acknowledgement of receipt. So acknowledgement of receipt is normally coming pretty quickly these days. I think most of my spousal applicants have received their AOR
Around a month or
pretty,
so.
yeah, pretty quickly after they filed, maybe about a month. Approval in principle is much further down the line. So that's when they've actually assessed the sponsor, made sure that the sponsor is eligible, and then they assess the foreign national applicant, make sure they're admissible, and there's nothing saying that, they think it's flagged for a marriage of convenience. Then they will give you this approval in principle letter. And so, if you are under a situation where you fell out of status, you filed under the old public policy, and you're really stuck, you might be able to use this, but you got to apply on paper and you have to have your approval in principle.
Yeah, exactly. All right. We are pretty much at the tail end here. Getting it right the first time, Alicia.
Yeah, and this is where, just like you said, Mark, there's so many things that if you don't follow these instructions, if you don't understand how to structure this application, if you don't provide IRCC absolutely everything that they need up front to approve your application, the processing times are so long that if something goes wrong, you're probably landing in a really tough spot. So it's just important to get it right the first time. So make sure that you've done your due diligence. I would recommend on these that you hire an immigration lawyer to help you with the process, because if you need to work and it's important, and you, especially if you had a prior work permit and you need to make sure you do have maintained or implied status, make sure that you're going through all the details.
Yeah. It's interesting, Alicia, as the government has taken the steps that they have to this point to make it just so miserable for applicants. I think, we've never been more busy. At least I haven't in my entire career. The reality is people are recognizing now that there isn't room for any mistakes and that those mistakes can have catastrophic consequences. And you may never get a second chance to fix things. For a lot of people, a lot of families, especially with these spousal sponsorships, finances are a big issue. And so they say, well, okay, it's not cheap, hiring you and your firm, Mark. We could save those thousands of dollars filing it on our own until you get a refusal. And the moment the refusal comes through, it delays everything. Maybe your work permit then expires. And if the person being sponsored is the principal applicant, which I've seen, then that person is not eligible to work. And then when we're looking at 6 months processing of a work permit, well, how much does a person earn in 6 months? And that's the equation that I help people look at, when they're trying to decide whether or not to retain us. But I've filed more spousal sponsorships in this last year than probably the previous 10 or 15. It's unbelievable, the volumes. And people are looking for whatever avenue they can to be able to stay. And this is something else maybe I'll point out too, Alicia. Never before have I seen IRCC questioning an in Canada spousal sponsorship, the genuineness of it, like I have now. And when
Hmm.
there's higher rates of fraud, higher rates of people maybe entering into marriages of convenience, immigration is starting to scrutinize things a lot more that they never would have before because of that fraud. So even the days of just saying, well, of course we live together. Everybody knows we're common law. It's not a big deal. We don't have a bank account in common because, we're a modern couple. We don't need to share everything. Well, you're going to be very, very surprised when you see the feedback that comes back from immigration, the procedural
Yeah.
fairness letters you get saying, hey, we don't think you're actually common law. We just think you're boyfriend, girlfriend, not, you don't have a centralized mode of existence. So all of these things are super important, and these are the things that we address with our clients as we're filing these.
And that's exactly the risk, Mark, right? Because if people didn't understand, if they thought inside Canada and they're inside Canada and they had to file a spouse or common law partner clause and they don't have enough proof or that application gets returned or withdrawn, then and they filed that open work permit in the meantime and they're counting on the ability to continue to work, well, it all falls down like a house of cards, right? If
Yeah,
that application is returned to them or if they can't continue to work. So especially if they can't continue to work and maintain their status, they have to leave, then they're going to lose the spousal even if it was accepted and was still processing. And so,
yeah,
you know, it's just making sure that the spousal is 100% correct and then making sure the work permit is done on time, exactly how it needs to be done well in advance.
exactly. All right, Alicia, thanks so much. And thanks everyone for joining us on this episode 171 of the Canadian Immigration Podcast. It's a delight to do these. We've had a little bit of a hiatus from them because of the summer and everything that's been going on, but we're looking forward to get back on track with these and releasing them. That's what happens when we've got a small team and we need somewhat of a break from time to time. And as we work directly with our clients, and so that model is a little bit challenging sometimes when we're trying to get all of this good information released. So thanks for joining us, and tune in again to another episode shortly. We wish you guys all the best as you navigate this crazy world we call Canadian immigration.